What do you do if you have in either your court order or in your custody agreement specified phone call time for your child's father, and either your kids don't want to participate or they're too young for it to really be developmentally appropriate and they're just not meaningfully participating? Hi, I'm Katie Carter. I'm a Virginia-based family law attorney, and for the last 14 years I've represented women exclusively in divorce, custody, and support cases, and this comes up a lot. The wisdom of including phone calls in your parenting plan is a different discussion entirely, but sometimes it happens. So what do you do? And it's such a catch-22 because, for one thing, the court wants to make sure that, that you're being held accountable, that you are allowing the phone calls to take place. They don't want to find out that you've obstructed them, but they also don't want to find out that you are kind of overseeing them. Like, you're not supposed to be just like hovering in the background during these phone calls. It's supposed to be kind of meaningful time between dad and the kids. So the amount that you can facilitate is really kind of limited because it's supposed to be a private conversation. And especially in a high conflict case, both parents being present during these calls can really make them counterproductive and, not aligned with what's in the best interest of the kids. I think your only obligation, though, is to make sure that the kids have access to an opportunity to take the calls. You can't make a 3-year-old sit on a call, whether it's FaceTime or not, and you can't make a 17-year-old participate in a conversation, as I'm sure you already know, that she doesn't want to have. So really your only obligation is to create the opportunity, not to force the conversations to take place, because as you've already kind of correctly identified, you can't do that. He has to make them want to have the conversation. And some of this going well is on him too.